Today, I submit this court can decide that 31C is bad, 39B and C still violates the basic features of the Constitution or basic structure of the Constitution. My lords, if it was a smaller bench holding that what is the effect of Minerva Mills, my lords may proceed in a different manner. But today, as 9 judges, my lords can certainly say, and even today find that Minerva Mills was right, or what is the impact of Minerva Mills, and you hold the whole thing. And that again, Mr. Andhyarujina pointed out, the series of judgment, now 2 judgments of 9 judges, both in Puttaswamy and Coelho have said that Constitution is a living document. From time to time, you may interpret it differently. And therefore, we want to raise this specific point, one on first principle, since it's open to my lords to confirm Minerva Mills or vary it or whichever you like. My lords can today hold, and we don't have to strictly go by the interpretation, what did Minerva say, what is the effect. Today, my lords are in a position where my lords can today say that we find that the amendment is bad and therefore it must go. Because if Article 14 is the essence of the Constitution, then even if you want to achieve the purposes of 39 B and C, you cannot do it in an arbitrary manner. You want to take away my property, you cannot do it in a discriminatory manner. You must follow some process. Even if you want to take over coal mines, etc., you cannot say, I do not like Mr. X or Y or Z, and therefore I only acquire your property and next door I do not. And that's the consequence if my lords holds 31C. And much water has flown down the Methi River, if I may say so. Article 31A is there. A, B, C, none of them were there in the Constitution. A protects all agrarian reforms. B protects anything put in the 9th schedule. 31C today is irrelevant completely because if anything the parliament wants to protect as a matter of 31A, it can protect it. If anything has to be put in the 9th schedule by a constitutional amendment, they can put it in the 9th schedule. And Coelho now protects me that maybe a higher standard, but 14 is still available to me, even if you put it in the 9th schedule. So therefore, 31C today has no substance, and my lord sitting in a combination of 9 judges can certainly decide that. And therefore, our submission is that para 17, and if my lords permits, that's really all I want to say, but I wanted to show a few paragraphs of Sanjeev Kokh, because it says these 3 things as I pointed out, and para 17 is what we had challenged. If I may, if my lord permits, page 2294 of volume 5 is where Sanjeev Kokh starts.
2307.
2307 it starts at the bottom, last paragraph.
Para 13. Yes, you can start.
First, it cites Keshwananda Bharti upheld the unamended 31C. Then, my lord, that's 2308.
Yes.
My lord. By the Constitution 42nd Amendment Act, the protection was extended to all laws giving effect to all or any of the principles laid down in Part 4. The dialectics, the logic, the rationale involved in upholding the validity of 31C when it confined its protection to laws enacted further to 39B and C should uncompromisingly lead to the same resolute conclusion that Article 31C, with its extended protection, is also constitutionally valid. No one suggests that the nature of the directive principles enunciated in other articles of Part 4 of the Constitution is so drastic or different from these directive principles B and C of 39 that the extension of constitutional immunity to laws made to further those principles would offend the basic structure of the Constitution. In fact, no such argument appears to have been advanced in Minerva Mills' case, and we find no discussion and no reference whatsoever separate to any of the distinct principles enunciated in the individual articles of Part 4 of the Constitution of Minerva Mills. The arguments advanced and the conclusions arrived at both appear to be general, applicable to every clause of Article 39 and every article of Part 4. No less clause B and C than the other clauses. We wish to say no more about the Minerva Mills case, as we are told that the pending review petition.
They doubted Minerva. They had to refer it to a larger bench. They couldn't have said this in the face of Minerva.
I'm grateful, my lord. And that's what we pointed out, that this is most improper, because sitting there, in fact, they are, and I did not read all those paragraphs because of paucity of time. In fact, they quote the entire dissenting judgment, in this case, from Minerva Mills. And therefore, also I'm urging that this honorable court in this combination may confirm Minerva Mills, because it's too late in the day to now say Minerva Mills was wrong. And in fact, Sanjeev Kokh doubts that. Then, my lords, para 15 onwards, and again, paucity of time, I'm not reading 15, 16. If I can come straight to 17, 17 is what we are. Because no, not confirm in the sense that only Sanjeev Kokh doubted the correctness of Minerva Mills, saying that issue doesn't arise. They say that it is obiter. there are findings.
In fact, in para 16, they say we broadly agree with much what has been said by Bhagwati Jay in the extracts.
Lordship, I'm deeply obliged, which is why, in fact, this judgment seems to suggest that the dissent is correct. And there are findings which say that Minerva findings are obiter because they didn't arise. And therefore, it would be appropriate today, in 2024, my lord, at the stage of constitutional history we are at, to confirm that Minerva was absolutely right, that both 3 and 4 are part of the same chariot, as my lords have called it, and both must work together. The aim in part 4 must be achieved through constitutional means of part 3. You can't say I jettison part 3 because I have some great objective to achieve. Therefore, you can't say I like industrialist XYZ and therefore I'll acquire their property because it's still 39B, but I don't like A by ABC, therefore I will not. Article 14 is that. There's nothing more to Article 14. It must be non-discriminatory. You can't pick it at your whims and fancies. And therefore there are multiple observations here which say Minerva Mills is only obiter. There is no finding there. And that, my lords, may clarify. That's all I was saying. But after that, my lords may see 14, 15 onwards is the second question which is finally decided in paragraph 17. And this is what we were challenging, and that is what 5 judges, when they referred, are also referring to. And that's why they were waiting for Coelho. And this is, if I can point out, para 17, page 2312. Just this last para, 17. We are firmly of the opinion that where Article 31C comes in, Article 14 goes out. We are challenging this, my lords. There is no scope of bringing in Article 14 by a side wind, as it were, that is by equating the rule of equality before the law of Article 14 with the broad egalitarianism of Article 39B, or treating the principles of 14 as included in principles of 39B. To insist on nexus between the law for which protection is claimed and the principles of 39B is not to insist on fulfillment of the requirement of Article 14. Now, much water has flown down the river since then, my lords. I would submit that today, my lords may hold that certain principles of 14, certainly, which will in fact impact the basic structure, can be a ground to challenge. Even if my lords holds that 31C is there, 39B is there, even then certain principles, and that is an issue that we specifically raised and was referred, and 5 judges and 7 judges therefore referred to these issues. Sanjeev Kok, Iyer, Coelho, that's why they said wait for Coelho. And that's the logic in which this. So therefore, my lords, today I would submit that my lords may hold and my lords can hold that Article 14.
Article 14 goes, you have read that particular paragraph.
Gotcha.
Article 14 goes, Article 19 goes, if a reasonable nexus is established
Gotcha.
between the statute and 39
Gotcha.
BC.
Gotcha.
In that context, it is saying that Article 14 goes.
Gotcha. Therefore,
Not,
my
there is no nexus. Not a sweeping remark like
no
that.
difficulty, Justice Dhulia is absolutely. But no, that's not. That's why after Coelho, that is not the law to this extent, and that's a submission that 1419 at a basic level may go, but if it amounts to affecting the basic structure of the Constitution, 1419 will still remain for a challenge, despite a protection from Article 31C. And I hope I've made that point clear. It may be a higher standard. It may not be the normal standard of 1419. But if an act protected by 31C with a nexus to 39B and C still violates the basic features of the Constitution or basic structure of the Constitution, it will still be open to this court to say under Article 14 we hold the law to be bad. And that's the context, and that's the constitutional development my lords have, in fact, over the years. 1419 has been raised much higher than it was at this stage of the constitutional history. And therefore, I submit my lords today can declare that 31C is no longer there. I don't only rely on revival or all those doctrines. Today, I submit this court can decide that 31C is bad. 31A and B are already there. The two articles, part 3 and 4, should be read together. And therefore, in fact, and 1419 to some extent is available. That's all our submission.